14th day of March 2025. I did, before Councillor Mutuma, before you speak, I did state at the beginning that I would give you hard copies. As I was reading through, I saw one or two spelling mistakes, little double words. I will work on those. It will be uploaded into CTS. You'll have it today. So I'll do that. You'll have it on CTS today. I have signed the hard copy as required by the law with my handwritten corrections of those spelling mistakes. Yes, Councillor Mutuma?
Yes, thank you, Your Lordship, for the judgment. We note the expedition nature in which the court has been able to dispose of this matter.
Yes.
My instructions, Your Lordship, is that we note from your judgment that a majority of the issues raised in the petition remain unresolved.
Yes.
And have been shelved and reserved for determination by the petition pending in Meru.
Yes.
We are therefore of a strong position that there is need to grant the petition an opportunity to have those issues which are the majority heard and determined.
Yes.
And since the court has had the opportunity to hear the issues being advanced by all parties extensively,
yes,
it will then appreciate the need for the issues, for the very weighty issues, to be determined.
Yes.
As such, Your Lordship, my instructions are to humbly request you to grant us temporary relief, in whatever nature, but specifically an order of status quo to be maintained in the prevailing period, aim to allow the petitioner ably prosecute the issues pending before the Meru court.
Yes.
And secondly, to also consider exercising a right of appeal in the Court of Appeal.
Yes.
This order of status quo, Your Lordship, can be structured in such a manner that it will be time-bound with the effect of automatically lapsing should the petitioner not have gotten a relief either from the Meru court or from the Court of Appeal. We submit, Your Lordship, that there will be absolutely no prejudice on any of the parties if orders of status quo are maintained. In any case, it is the situation that has been prevailing since August 2024. Having that situation maintained for the next few weeks or months will not in any way prejudice the petitioners.
This one, please repeat the period.
The period, my submission to Your Lordship is that in any case, the status quo has been prevailing since August 2024. There will be no prejudice if that same situation is maintained in the next few weeks, or rather for the next few weeks or months, just to ensure that the very weighty issues that the court has appreciated will have an opportunity to be determined on merit. The contrary is true, Your Lordship, that should an order of status quo not be issued, then effectively, whatever is pending in Meru, whatever is pending in the Court of Appeal, like the court has ably noted, is all rendered an academic exercise.
Yes.
By dint of Article 23, we humbly request the court to issue conservatory orders post-judgment. And to expedite our next move, Your Lordship,
Yes.
we humbly then request the court to direct the Deputy Registrar to supply us with typed proceedings in this matter.
Yes.
And a copy of a certified judgment. That is all, Your Lordship.
Ms. Sani?
Yes, thank you, my lord. My lord, we oppose the application for the first reason that this court has identified.
You oppose?
Yes, we oppose the application. My lord, in your judgment, this court has identified that the petitioner's action of approaching two different courts was for this purpose exactly. This application is not to dismiss the respondents from enjoying the fruits of their judgments after this court has started and had parties on merit. I know it is not true that there will be no prejudice. The court has found that on merit, the Senate did conduct a proper process within the law.
Yes.
And further suspending that process is not in the interest of justice. It is not in the interest of Article 10. And it is not what is envisaged under Article 181.
Yes.
My lord, the petitioner having been found to be worthy of leaving office pursuant to Article 181, she has remedies in other courts, but at this point, this court is found insufficient. My lord, the Meru court is seized of the matters pending before it, and you have rightly declined to deal with those matters. That court can make appropriate orders concerning this issue. That court can quash any process. They have the power to do that based on the material before them, which is not before you this afternoon. My lord, in the Wajir impeachment case, the court quashed the impeachment and the process proceeded after that. But for this court to be asked to take action based on the matters before the court in Meru is not proper, and it is negating the judgment delivered this morning and further suspending a proper decision of the Senate. My lord, we oppose. Thank you.
Just a moment. So we have quite a number of interested parties. So I will call on one from each side. First interested party, Councillor.
Thank you, Malone.
Yes.
Thank you for the industry that the court has shown in determining this dispute with the time that it has slowed down. A lot we wish to submit to associate ourselves with the application by the petition. With regards to the request for a status quo order, this will enable the parties to ventilate the issues that the court has so referred to. The petitions have filed in mail.
Yes.
And these interim orders will be able to avoid the disruption of the governance. We also wish to request for time copy of the proceedings as well as certified copies of the time. That is all I'm saying.
Councillor Kirimi.
Thank you, my lord. On behalf of the interested parties who opposed the petition, my lord, first and foremost, to thank you for the good judgment that you delivered. And my lord, on behalf of all my colleagues who appeared before you, and as the senior most counsel perhaps who appeared before you, we are sincerely grateful for the opportunity to canvass the issues we did before you. My lord, so that I want to come again before you.
Yes.
We are also sincerely grateful to yourself for the professional courtesy that you extended to us.
Yes.
My lord, in a specific way, we are very grateful that you found in your heart to forgive us when we did not appear to be proper before you.
Yes.
And we thank you specifically for pushing yourself and ourselves to meet the strict timelines that you set to advance this petition before you. My lord, turning to the application by Mr. Mutuma, we do oppose the same.
Yes.
First, you are now franked as official. Secondly, my lord, the weighty issues Mr. Mutuma is raising from the bar cannot be raised in an oral application. We kindly suggest that the petitioner finds it proper to file a formal application before you for urgent consideration and for a formal opportunity to all parties opposed here to file a response. Thirdly, Your Lordship, by making any decision that will amount to a stay of the negative